I do not care. Okay.
Right.
I know the program pretty well. I'm, again, a big supporter of them, and I think it'll be good, but just, you don't leave without asking my permission. You got it?
Yeah, absolutely.
All right. So, Mr. Huntley, involve yourself, throw yourself deeply into the program.
I appreciate you, letting me do this. I've been trying to get help for a minute now, and it's been a tough road. And,
Mr. Huntley, I appreciate that. And, criminal courts and cases aren't always about punishment. They are also all about rehabilitation. And I want to ensure that you get that opportunity. And based upon the scoring of the guidelines, it gives me kind of an idea of what criminal history you may, or even more importantly, may not have. Now, again, do not leave.
I'm taking full advantage of it.
Okay.
I've been doing everything I can in the jail as well.
Exactly.
CHS
Good.
and AA. So
Good. We
I
work
meant to
hard.
bring my stuff with me, but I didn't know if
That's
I could
okay.
bring my.
No, you're fine.
Good advocate for yourself.
Yeah, no, we work really hard to get people treatment even while they're in the jail. So
I appreciate that.
I'm glad that you're using it. All right, thank you. Anything else, Ms. Dahl?
No, Your Honor.
For an upcoming trial. Is the trial date?
June 9th.
Oh, June 9th. All right, thank you. I've got a pre-trial agreement here. Here's what I understand is going on based upon the paperwork presented to me. The defendant, who is charged with possession of the controlled substance methamphetamine, as with two different enhancements. If the defendant pleads to count one, the enhancements will be dismissed. Is that correct, Ms. Dahl?
Yes, Your Honor.
Is that correct, Mr. Harrison?
It is so far.
And Mr. Huntley, is that what you think we're doing?
Yes.
All right, to the best you can, please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Thank you, Your Honor.
You may lower your hand. Mr. Huntley, looking back on August 27th of last year, which is the date of which this offense allegedly occurred, were you on probation or parole?
I was.
And has there, which one?
I was on probation.
And has there been a probation violation conducted?
No, they discharged me from probation.
All right, so there's no risk of probation
No,
violations?
Not at this point, no.
All right. The next question is were you on bond pending any felony charges?
No.
All right, good. All right, so I'm going to go over this pretrial agreement a little better. If you have any questions, all you got to do is let me know. You are currently charged with a single count of possession of the controlled substance methamphetamine. Now that's a felony punishable by up to 10 years and or up to $15,000. Now there are two sentencing enhancements that are going to be dismissed, but I need to tell you what they could do. First one is you could be sentenced as a second or subsequent drug offender. What that means is at the time of sentencing, within the discretion of the court could increase the potential sentence from up to 10 years to up to 20 years. And from up to 15 to up to $30,000. Or you could be sentenced as a second habitual felony offender. In that instance, again, within the discretion of the court, the maximum sentence could be increased from up to 10 years to up to 15 years. However, if you enter a plea of guilty today to count one, and I accept that plea, the prosecution agrees to dismiss the request to treat you with one of those enhancements. Do you understand?
Yes.
All right, thank you. Now, I have this written pretrial agreement here, and it looks like it's got a signature on the bottom that might be yours. I'm going to point to it. Is that your signature there on the bottom left?
It is, Your Honor.
Now, did you talk to Mr. Harrison about this agreement before he signed it?
I do.
And was he available to answer your questions about options and facts and evidence and things like that?
Absolutely.
And are you satisfied with his advice, at least as up to now?
Yes.
All right, thank you. Now, if you enter this plea and they accept that, you're going to waive certain rights and not have a trial. Does that make sense?
Yes.
Well, good, because I have a second piece of paper that I'll hold it up. And it appears to have your signature again at the bottom. Once again, is that your signature?
It is, Your Honor.
And before you place your signature on this piece of paper, did you read through all of these rights?
I did.
And don't take offense to this, but did you understand all the words?
I did, Your
All
Honor.
right, good. And so do you understand again that if you enter a plea of guilty and accept it, you'll be forever waiving these rights, at least as they apply to this particular case?
I do, Your Honor.
All right, thank you. Additionally, you'll be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record. Have there been any other promises, threats, inducements, force, whatever to get you plea guilty?
No, there hasn't.
Therefore, are you entering this plea of your own free choice?
I am.
Thank you. Now, Mr. Harrison has undoubtedly talked to you about potential sentencing. He's probably talked to you about the Michigan sentencing guidelines. Is that true?
Yes.
He's also probably tried to give you his esteemed wisdom and experience of being in front of me a lot and trying to give you an idea of what I'm likely to do. Is that right?
Yes.
Now, the key question is, has he or anyone promised you what I'm going to do?
No.
Knowing all that, sir, do you still wish to enter the plea of guilty that we discussed earlier?
I do.
All right, thank you. As to the single count, possession of methamphetamine. Sir, how do you plead?
Guilty.
Before I can accept that plea, I'm going to ask you some questions. On or about August 27th, 2025, out in Wexford Township, way up in the northwest corner of the county, here in Wexford County, what happened?
We were pulled over in a car, and I had possession of a small amount of methamphetamine.
Where was it?
It was in my pocket.
Okay, and did you, forgive me, these sound silly questions. Did you know it was there?
Yes, I did.
And did you know that it was methamphetamine?
Yes, I did.
Now, sometimes people will come back and say, well, listen, I didn't really know because the baggie was clear and I couldn't, what, was there something in there? Was it in a baggie?
Yes, it was.
And did you actually see it in there to some degree?
Yes.
All right, good enough. Now here comes the next question. In your mind, did you have any lawful right to possess that methamphetamine?
No.
All right. All right. Ms. Dahl, you believe you've provided the factual basis to support the plea?
Yes, Your Honor.
Are you aware of any other promises, threats, or inducements of which we have not discussed?
No, Your Honor.
And you believe the court's compliance with clause 6.302?
Yes.
Mr. Harrison, do you agree with all those?
I do.
I did. I covered Wexford
Did you?
County. Remember, I even said stuff in the northwest part of the town. It's okay. You agree this occurred in Wexford County here in the state of Michigan,
Yes.
in the United States of America.
Absolutely.
Is that all right, Ms. Clark? No,
Sometimes here.
no, it's all right, because I may have missed it. All right. All right, Mr. Harrison, did you agree with all three?
I did, sir.
Thank you very much. The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds that the defendant provided a factual basis for the plea. The plea again was made freely, knowingly, and voluntarily. Therefore, the defendant is found guilty of count one. At the time of sentencing, the enhancements will be dismissed. I know what you're going to ask, Mr. Harrison, so hold on. Sir, we're going to be back in about a month, maybe longer.
Okay.
That's what Mr. Harrison's going to ask me about here in just a moment. Between now and then, an agent from the Michigan Department of Corrections is going to prepare what's called a pre-sentence investigation report. That includes 3 steps for you. Number one, you're going to get a packet, and Madam Clerk is getting ready to give it to the bailiff. There it goes. Good handoff. You're going to open it up, fill out the information, turn it back in. Second step is you'll be subject to an interview with an agent from that office. And you have the right to have Mr. Harrison present during that interview. And third, prior to coming back to sentencing, Mr. Harrison's going to have to go over that report once it's received, because each side has the right to come to the court, request corrections, make objections to scoring the guidelines and other things that are contained therein. This report must be prepared anytime someone's convicted of a felony here in a state court in Michigan, and it will include a description of the offense, description of the pretrial agreement, any statements or information you make or provide while it's being prepared, information about prior criminal history, and even more importantly, often a score to the guidelines. Again, by the way, the guidelines are not mandatory. And it will have a recommendation as to the sentence. It's not mandatory either, as I make up my own sentences. And it will have information about probation in the past, how you performed on bond in the past. Those things go a long way with the court in trying to help establish what I think is a reasonable and proportionate sentence. Do you understand?
I do.
All right. Go ahead.
We actually filed a written motion
I have it.
before the court this morning with regard to, of course, we would request a personal recognizance bond after the entry, particularly after the entry of this plea, because we scored Mr. Huntley at 0 to 17. That notwithstanding, he has done the legwork and obtained a placement with Addiction Treatment Services.
Is this bed still open? Because I see it's.
Yeah, the motion is a bit incomplete because of the timing of it. I do have an updated treatment or access letter that indicates that he has a bed date of Monday. This says Monday, May 29. Well,
I know, that's
May 29 ain't no Monday.
Friday.
We'll cover that, but this letter does indicate that he has a spot available. But all of the other terms haven't changed as set forth in the motion, except for the fact that now he's entered this plea. I had referenced a plea agreement or plea offer that had not yet been enacted when I filed the motion.
Got it.
If I may approach.
Oh, yeah, I'll just go thank you. Thank you, Ms. Dahl. Position of the people.
People take no position.
All right, thank you very much. Okay, well, I'm an avid supporter of substance abuse treatment. I talk to the people, the manager of addiction treatment services often. In fact, I talked to her yesterday. So I'm willing to do it. So here's what we're going to do. The court will grant the motion. The court modifies the bond as follows. The defendant will be released from the Wexford County Jail. It'd be nice if I knew they meant Monday or they meant the May 29th.
She did mean the 29th. That's what she verbally conveyed to Mr. Heininger.
All right, beginning on May 29th. And he will be transported by the Wex Express. He'll be released on May 29th on a personal recognizance bond. The condition of his release is that he will be transferred by the Wex Express to Dukoski Hall up in Traverse City. He is to enroll and participate in the inpatient treatment program there. If he leaves the program unsuccessful or is removed from the program unsuccessfully, he must report back to the Wexford County Jail or a bench warrant will be issued. You must also sign a release that allows our office, which is called Community Corrections, to monitor your attendance. When you sign this release, it is not to allow them to look into your personal file, your medical information, know what you're talking about with counselors. It's just so the staff down there can call and go, is he still there? All right, good. Have a great day. That's it. Because I've ordered you to go to a place, and the only way I'm going to know if you actually went there and stayed there is if I can have somebody know that you're there. That's it.
Absolutely.
Now, if they have if this is a 30-day program or they have a continuation program, and if your sentencing date comes up before you've completed it, Mr. Harrison knows he can ask to adjourn it. Okay? And I will adjourn it as long as you are compliant with their terms and conditions. I want to ensure you get the maximum benefit of their program. Now, sometimes, I don't think I've had this problem with ATS. Sometimes people will leave and go, well, I just didn't like the other people that were in the program, or I didn't like that one counselor. Anything else, Mr. Harrison?
Nothing further, Your Honor. Thank you.
Thank you very much, Mr. Allen.
Thank you, John.
We're adjourned. Thank you. Our next file this morning is People of the State of Michigan versus Richard B. Faylor. This is case number 25-14164 FH. Oh, wait. All right. So first, let's cover appearances.
Joanna Gary, principal.
I'm Jeff Harrison. I'm here on behalf of Mr. Faylor. I'm standing in for Bob Champion today.
All right. And Mr. Faylor.
Mr. Faylor's witness too.
Thank you. Now, I recall the last week receiving a request to adjourn and there wasn't a lot of explanation about it. So, and I wasn't trying to say, heck, no, I ain't gonna adjourn this thing. I just wanted to have a better explanation. If the parties, because I know what connection this case has to others, if you wish to need to speak with the court in chambers.
Yes, please.
Okay,
Now,
I think that's an excellent idea, Your Honor.
okay, so let me turn to you, Mr. Faylor. First of all, I don't like necessarily going into chambers, but it's within my discretion if the parties ask for it, and that's okay. If you have any questions about what happens in there, you just need to ask Mr. Harrison, okay? I don't want you to think there's anything ill toward going on in there. But I can find and do for the matters and interests of justice that it's appropriate. Now, typically on final pretrial conference day, it's the last day before your case is going to come before me for the trial. And final pretrial conferences to me are the last day to enter a plea pursuant to a plea trial agreement. The reason I do that is never to force a defendant to do anything. The reason I do it is to force the attorneys to do the best job they can for you and for everybody else. So that way, when you leave the courtroom or any defendant in that chair leaves, they don't go, I bet if I show up on trial date, I can get a sweeter deal. No, because I want to make sure that the attorneys have done all their brilliant arguing and negotiating and stuff like that, because you need to know this is the cutoff. And the attorneys need to get witnesses brought here, subpoenas. People have to take time off of work because I know what this case is about. There's going to have to be a lab technician has to leave his or her job and come here. I also know I've got to have 60 or probably 90 potential jurors come into the courtroom. That's the reason I have the deadline. All right. So I know the parties are going to ask me and explain to me maybe why this case should be adjourned. But I want you to just know that and hear it from me. Understand?
I understand.
All right, good. And I generally put this all on my schedule, which you should have received.
Right.
So, all right, we're going to see if I can take up some other cases though. So I'm going to push this one off. We'll just recess and hold on. I will. Yeah, I'll recall it and say if we're going to. We're just going to recess. Go ahead and take a seat back there. Thank you. All right, our next file this morning is People of the State of Michigan versus Kevin Lee Peterson. This is file number 26-14191FH. Appearances from counsel, please.
And I am Jeff Harrison. I'm here on behalf of Mr. Peterson. I apologize for not rising, Your Honor. I had neglected to sign one of the documents I intend to present to the court, if I may approach right now.
No problem, sir. You may have a seat.
I should note for the record that Mr. Peterson is present as well.
All right, thank you. Mr. Peterson is not in current pretrial custody. Today is set for a final pretrial conference. This case is one of those set for a trial to begin on June 9th. Mr. Harrison has just provided to me a couple of documents. One is an advice of rights, and the other is a written pretrial agreement. Mr. Peterson, is it your intent to enter a pretrial agreement today?
Yes, Your Honor.
Please raise your right hand. Sir, do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes, Your Honor.
You may lower your hand. Mr. Peterson, looking back on December 20th of 2025, were you on probation or parole at that time?
No, sir.
Were you on bond pending any felony charges anywhere at that time?
No, sir.
Thank you. You are currently charged on a felony information, which is just a charging document. And you are charged with 2 offenses. Nope, take it back. 3 offenses and a couple enhancements. And I'm going to go through those and then talk to you what I believe the pretrial agreement to be. Then I'll turn to the attorneys to make sure I've got it stated correctly. Now, count 1 is a charge of possession of the controlled substance cocaine in an amount of 50 grams or more, but less than 450 grams. Now, that's a felony punishable by up to 20 years and or up to $25,000. There is also a sentencing enhancement called a second habitual felony offender that could, within the discretion of the court, allow the court to increase that potential punishment from up to 20 years to up to 30 years. However, looks like count one and that enhancement will be dismissed. I think, I don't see it written on the agreement, but am I correct? The enhancement's being dismissed?
Yes.
Okay,
That's correct, Your Honor. I
That's all right.
apologize.
I got it.
Was incomplete.
count two charges you with the offense of operating while intoxicated as a third offense. Now, initially, an operating while intoxicated is a misdemeanor punishable by up to 93 days and or a minimum of 100 to a maximum of $500 in fines plus cost, and 360 hours of community service, vehicle mobilization, cost of prosecution. But as a third offense, which means you have at least 2 priors, it is increased to a felony. And in that essence, the minimum punishment, it includes the following punishments: a minimum of $500 to a maximum of $5,000 in fines and costs, and then either a minimum of 1 year to a maximum of 5 years in prison, or a combination of probation and a minimum of 9 or 30 days to a maximum of 1 year in the county jail. At least 48 hours must be served consecutively, and or it could be a minimum of 60 to a maximum of 180 days of community service. Now, there is also the second habitual felony enhancement that could apply also to that at the time of sentencing within the discretion of the court. That could have allowed the court to increase the potential punishment from up to 5 years to up to 7.5 years. However, I'm told today that you're going to plead guilty to count 2. And then if you do, and I accept that plea, the prosecutor again agrees to dismiss that second habitual felony offender enhancement. Count 3 is a charge of operating while your license is suspended, denied, or revoked. Typically, it's a 90-day misdemeanor punishable by up to 93 days and or $500 in fines plus vehicle mobilization. But it's alleged here that you had a second or subsequent offense, which means it is increased to still a misdemeanor, but up to a maximum of 1 year and or $1,000 in fines and costs plus vehicle immobilization. I'm told, however, that charge will be dismissed. Is that correct? It's not on the form, that's why I'm asking.
I believe that to be the case.
Sorry.
The driving license suspended, it's not listed on the agreement as being pled to or dismissed.
It will be dismissed. Thank you. I'm sorry.
That's okay.
I missed it too.
All right, do you need me to repeat any more of that information, Mr. Peterson?
No, sir.
And did I get the terms of the pretrial agreement correct, Ms. Carey
Yes.
and Mr. Harrison?
You did, you know.
All right. Now, I have here this pretrial agreement that was presented to me by Mr. Harrison, Mr. Peterson, and I'm holding it up. On page 2, it has your signature. Is that your signature?
Yes, Your Honor.
Now, before you signed that, did you talk about this pretrial agreement with Mr. Harrison?
Yes, Your Honor.
Before doing so, did he talk to you about the case, the charges, your options to go to trial, not go to trial, and the evidence against you and things you could do?
Yes, sir.
And was he? So the key is he was available to answer any of the questions that you had of him.
Very much so.
All right,
Yes.
good. Are you satisfied with his representation as of now?
Yes, Your Honor.
Now, the second piece of paper I'm holding up is something called an advice of rights. And again, at the bottom, it appears to have your signature. Is that your signature?
Yes, sir.
Now, did you read through all these rights before you signed it?
I did, Your Honor.
And did you understand the words that you read?
I did.
And even more importantly, do you understand that if you enter the pleas of guilty that we just discussed, and I accept those pleas, you'll be forever waiving these rights as they apply to this particular case?
Yes, Your Honor.
Additionally, you'll be given up the right to claim that the plea was a result of any promise, threat, or inducement not told me today on the record. Have there been any other promises, threats, or inducements to force or compel or entice you to plead guilty?
No, Your Honor.
Okay. Well, I forgot one thing. You guys didn't catch it, but I did. You're also going to enter a plea of guilty to an added count 4, and that is possession of the controlled substance of cocaine in an amount less than 25 grams. Now, that is a felony punishable by cocaine's on the rise if she gets this memorized. Up to 4 years?
It was a 4-year, I believe it's an eager, Your Honor.
Yeah. And the next thing is, I don't remember the money. It's not 4,000. It's relatively high. It's like it's 15,000. It's pretty stiff, even though it's a lesser grade. And it's treated a lot lighter than methamphetamine. So this would be MCL 331.7403 something.
Two B three, I believe, or this is 284.
3. Yes, 4 years and $25,000. By the way, I've never assessed $25,000. Nobody can pay $25,000. It doesn't make sense. I'm sure whatever the legislator who pushed that is probably very proud of him herself. But anyways, you understand you're going to plead guilty to that count? And there's no enhancement, so it's not increased by a second as a co-offender. All right, thank you very much. All right, so I went over the rights. I also need to go over. Are you entering the plea of your own free choice?
Yes.
Anybody forcing you to do this?
No, yeah.
No? All right. Now, Mr. Harrison's probably talked to you about sentencing. Has he talked to you about something called the Michigan Sentencing Guidelines?
Yes.
And I want to highlight for you, those guidelines are not mandatory. While the court must use them to help establish a sentence, the court need not follow them. He's probably also trying to give you an idea of what he thinks this judge here will do, because he's in front of me every week, multiple times, and he loves it every time. Not really. But the key question is, has he or anyone promised you or led you to believe exactly what I'm going to do for sentencing?
No, Your Honor.
Knowing all that, do you still wish to enter the pleas of guilty that we talked about?
Yes, Your Honor.
As to count 2, operating a vehicle while intoxicated or impaired by a controlled substance, how do you plead?
Guilty.
And as to the added count 4, possession of cocaine in an amount less than 25 grams, how do you plead?
Guilty.
Before I can accept those pleas, I need you to tell me what it is that you did that makes you guilty of those 2 offenses. So I'm going to turn your attention to December 20th, 2025, in the city of Manton, Webster County, in the state of Michigan. What happened? Were you operating a vehicle at that time?
Yes, Your Honor. I was coming back from a friend's house and made some poor choices and extracurricular activities that I was involving myself in.
Okay.
And
So it looks like you were driving down to Michigan Avenue downtown.
correct.
And so an officer stopped you?
Yes, I was leaving the gas station getting gas.
Okay. And when that officer stopped you, had you consumed some kind of controlled substance?
I had.
All right. And is there a blood draw result?
There is a blood draw.
All right. And does it demonstrate that he did have some substance in his system?
In his system was cocaine, methamphetamine, and one I can't pronounce.
That's all right. We only need 1, but you got 2.
Yeah.
Mr. Harrison, does the defense so stipulate for the?
I do.
Thank you. And when so sure you knew you had some of these atoms in your system, at least the cocaine and stuff?
Yes.
All right. Now, did you possess some cocaine also in the vehicle, on your person or in your area of control?
I had, yes.
Where was it found?
It was in my pocket, myself.
Okay.
Yeah.
Did you know it was there?
I did.
All right. So it wasn't like a jacket you picked up in the trash?
No, sir.
I love it when people try to tell me that one. And so what kind of container was it in?
A small vial or bottle.
So if that bottle were open, could you actually see a bit of it still in there?
Yes.
All right. And did you have, in your opinion, any lawful right to possess that amount?
No, yeah.
And it was some amount that you could see?
Yes.
That's all I need. I don't need you to tell me exactly how much, because anything less than 25. Now, additionally, is it true, Mr. Peterson, that back on July 1st of 1998, looks like in the 87th B District Court in Kalkaska. You were convicted of operating a vehicle while impaired. 98, it's a long time
Yeah,
ago.
it was a lot.
Yes.
Yes,
I can show you.
and
this.
Okay.
also, is it true that you were convicted a second time of operating a vehicle while impaired? Just 2 years later on August 3rd of 2000,
Yes, yes, Your Honor.
and that was also up in Kalkaska County?
Yes, Your Honor.
All right, good enough. Thank you very much. Ms. Carey, do you believe the defense provided a factual basis to support the pleas?
I do.
Mr. Harrison?
I am likewise satisfied, Your Honor.
Ms. Carey, you aware of any of the promises, threats, or inducements?
I'm not.
Mr. Harrison?
No,
Ms. Carey, you believe the court's complied with Fish Crawl 6.302?
Yes, sir.
Mr. Harrison?
you have.
Great. I agree. The court finds that defendant's pleas today are made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the required elements of proof. Therefore, the defendant is found guilty of count 2, operating a vehicle while under the influence of a controlled substance as a third offense, and added count 4, possession of cocaine in an amount less than 25 grams. That's under MCL 333.74032. I'll just leave the rest of it to the clerk. All right. The other charges and enhancements will be dismissed at the time of sentencing. Mr. Peterson, when you leave this courtroom, go downstairs to the probation and parole office, also known as the Michigan Department of Corrections. Do you know where their office is located?
I'm certain I can find it.
I'm sure you can too. Have you gone to community corrections for testing?
My testing I have done, I live in Kalkaska, so
Yeah.
my testing I've done there, and then I emailed the results to them.
Well, you probably had to go there to register,
Okay.
right? If you were to stand in front of that window, do an about face and walk 4 steps,
Okay.
you'd be in front of the probation office. They're going to give you a packet. You're going to complete that packet and turn it back in. You're going to have an interview with Mr. Harris or with that agent, and you have the right to have Mr. Harrison present. Mr. Harrison also needs to make sure you get a hold of me, because before coming back here for sentencing, he needs to go over that report and its contents with you. Each side has the right to come back to this court and request corrections or make objections to the content of the scoring. Please keep in mind that the guidelines, again, are not mandatory, and this report will also include a recommendation as the sentence. Please trust me, it's just a recommendation. I don't always follow them. All right. This report will include a description of the offense, description of the pretrial agreement, any statements, information you make or provide. It's going to include scoring the guidelines, a recommendation for sentence. It's also going to tell me about your criminal history, and even more importantly to me, what you've done for rehabilitation, if you've done any, and how you've performed on bond and probation, either in this case or in previous cases. All right, any questions?
No, Your Honor.
Thank you. Anything else, Ms. Carey?
No, thank you.
I should have asked, any objection to the continuation of bond?
No, sir.
Thank you. Mr. Harrison, any further?
Nothing, Your Honor.
Your
Thank
bond
you.
conditions remain in effect, Mr. Peterson. Again, before you leave the building, go to that office. If you take the elevator, or preferably the steps, because everybody needs steps, take them all the way down to the bottom. If you walk out and do a right face, you'll see a little wall with all the military stuff on it. Walk straight and then into the doorway. Thank you very much. We're adjourned.
Look at me.
All right, our next file this morning is People of the State of Michigan versus Laura Marie Webster. This is file number 26-14193. We are here today on this file for a final pre-trial conference. This is one of the cases set for trial June 9th. Appearances from counsel, please.
Lisa Dahl for the people.
And I'm Jeff Harrison. I'm here on behalf of Ms. Webster. Your Honor, before we get to, I should note that she's joined me at the table. This may be another one that would behoove us to discuss in chambers,
Okay,
along with Mr. Faylor's situation, if we could.
they're related, not maybe friend-wise, but or family-wise, but no. All right, well, I'll take it. We'll do it. Again, and before I go in there, Ms. Webster, again, this is within the discretion of the court. It's not dispositive and not an adversarial meeting, so I'm going to go in there and talk to the council. I used to do all my final pretrials initially in chambers and then come in here. So it's not any big deal. I want you to know, obviously, Mr. Harrison will come and tell you anything that goes on. Do you understand?
Yes.
Again, you've already heard of a time or two today. Final pretrial conferences are generally the last time to enter a plea, something less than as charged. And that's never to force a defendant to do anything. It's just to force the counsel to make sure that they have exhausted all their skills and they're not waiting for the pressure of having all the jurors here to go, oh my God, we're going to cut a better deal. Because you need to know when you leave here today, you need to have some certainty as to what's happening. Also, I need to know if I really need to have 100 people come in for jury service. All right, thank you very much. We're going to just recess this one. I'll address that one in chambers. Thank you very much. And our next file. Our next file is People in the State of Michigan versus Jamaria Joseph Jackson. This file number is 26-14213 FH. Appearances from counsel, please.
Joanna Carey to the people. Good morning, Your Honor. Marie Vandenberg, excuse me, on behalf of Mr. Jamaria Jackson, who was present at my lot.
All right, thank you very much. We're here today also on this file for a final trial conference. This is one of the cases currently set for trial to begin on June 9th. All right. So what are we doing with this case today? Whichever one wishes to speak. Ms. Carey, how about you?
I believe Ms. Vandenberg should speak.
All right, good.
Thank you, Your Honor. Thank you for the opportunity. I don't want to mimic what was just stated before this court earlier, but if we can have a chamber conference, I think it's very important. There's some things that I'd like to just bring forward. I mean, it's probably not, should not be on the record.
All right, we'll go ahead and just put that in a recess. Mr. Jackson, you heard what I said to everybody else about final pretrial conferences?
Yes.
All right, thank you. So I don't need to repeat it again. I will just push this case aside. Looks like this is probably a good thing because I only had one cup of coffee and that was hours ago. All right, we'll recess on that one. Let's give me another one. Good morning.
Good morning.
And a new blouse. I haven't seen that. Very colorful. Yes, ma'am.
This will be the last time.
All right, thank you. Our next file is People of the State of Michigan versus Teresa Christine Evans. File number is 26-14214 FH. Let's hear appearances from counsel. Do I have a defense attorney? There he comes.
Lisa Dole for the people.
Thank you.
I'm here on behalf of Mrs. Evans. She's joined me at the table. If I may approach, Your Honor, I have some documentation that will likely be of interest to the court.
All right, thank you. We're here today for a final pretrial conference. So far, this case is still set for trial on June 9th, but Mr. Harrison has just handed to me a written pretrial agreement and an advice of rights. Ms. Evans, you understand today you intend to enter a plea, is that correct?
Yes.
Before we go over the terms of that pretrial agreement, please raise your right hand. Ma'am, do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth? Thank you, Ms. Lawyer Ann. All right, Ms. Evans, looking back on September 2nd of this past year, were you on bond or probation?
Probation.
And has there been a probation violation held?
No.
So there's no more risk if that, is that correct, Mr. Harrison?
That is correct, Your Honor.
Ms. Evans, were you on bond at that time pending any other felony charges? All right, thank you. You are currently charged on a felony information with 2 counts. Nope, sorry, 1 count, but with 2 enhancements.
Am I going to Webster?
Count. Hold on, everybody. There we go. Count 1 is possession of the controlled substance methamphetamine, which is a felony punishable by up to 10 years and or up to $15,000. Now, there are 2 potential sentencing enhancements that have the same effect. And that means that at the time of sentencing, there'd have to be 1 pick. But either way, it would mean that within the discretion of the court could increase the maximum penalties from up to 10 years to up to 20 years, and from up to 15,000 to up to $30,000. But I'm told here today that you're going to plead guilty to something else. You're going to plead guilty to a added count 2 of use of the controlled substance methamphetamine, which is a felony punishable by up to 1 year and or up to $1,000. But I'm told you're going to plead as a second or subsequent drug offender, which could increase that punishment from up to 1 year to up to 2 years, and from up to $1,000 up to $2,000. Yes?
Your Honor, I believe originally it's a 1 year with a $2,000 for use of methamphetamine.
All right, thank you. So it's a one, not 1,000, it's up to $2,000. All right, so,
That sounds right.
yeah,
I don't think it's critical to her decision.
I don't think so. I've never given $2,000 for it, but all right, maybe I will. I don't know. But anyways, you'll be pleading as a second or subsequent, which doubles that amount. Do you understand? Now, because that happens, it becomes a felony. Is it a felony or a high court misdemeanor?
I've always regarded it to be a high court misdemeanor. However, in subsequent PSIs, it will score as a low severity felony.
That's true. So a high court misdemeanor is this hybrid of a misdemeanor and a felony. I don't really know if I understand the reason for it, because if it walks like a duck and talks like a duck, which means if it's punishable by more than a year, and it can be used for scoring later on if there's ever another conviction, and it can be scored as a felony, it's a duck. I mean, it's a felony. You got it? But it's called a high court misdemeanor. You understand? All right. Well, I still think it's important that you understand. Okay. And if you do enter that plea, and I accept that plea, the other charges will be dismissed. Is that what you understood you were doing today, Ms. Evans? Ms. Dahl, did I get the terms of the agreement correct?
Yes, Your Honor.
Mr. Harrison, did I get them correct?
I believe you have it. Thank you.
Now, Ms. Evans, Mr. Harrison has provided to me this document that at the top says plea agreement. At the bottom appears to have your signature. Looks like it's right there. Is that your signature?
Yes, sir.
Before you put that signature on there, did you talk about this pretrial agreement with Mr. Harrison?
Yes, sir.
Was he available to answer your questions about cases, evidence against you, rights, things like that?
Yes, sir.
And are you satisfied with his advice as of today?
Yes, sir.
All right, thank you. Now, if you enter a plea of guilty, as we discussed, you're not going to have a trial of any kind. Does that make sense, Ms. Evans?
Yes, sir.
All right. Now, I have here this advice of rights form. I'm holding it up. Is that your signature on the bottom?
Yes, sir.
Now, before you sign that, did you read through this document?
Yes.
Did you understand the words that you read?
Yes, sir.
And even more importantly, you understand that if you enter a plea of guilty and I accept that plea, you'll be forever waiving these rights as they apply in this particular case.
Yes, sir.
All right, thank you. Now, when did you sign this piece of paper? Was that earlier today? All right, thank you. I'm just
Oh, I
gonna,
didn't put the date on there. I apologize to the court.
it's okay. I'm just gonna add it on the bottom. Thank you. And note that on the record as they have.
Yep.
Now, Ms. Evans, you also will be given up the right to enter, later come back and say that the plea wasn't of your own free choice, that there was some other promise, threat, or inducement. So I need to know, other than the terms of the agreement, have there been any other promises, threats, or inducements to force or compel you to enter this plea? Are you doing so then of your own free will?
Sure.
And Mr. Harrison's probably talked to you about potential sentencing guidelines, and we already mentioned that this would be scored on the H grid offense level. Has he talked to you about potential sentencing?
Yes.
Okay.
We did in general terms today, Your Honor.
The key question I have for you, Ms. Evans, is has anyone promised you or led you to believe exactly what the sentence would be from me? You still wish to enter the plea as we discussed?
Yes, sir.
As to the added count 2, use of the controlled substance methamphetamine, how do you plead?
Guilty.
Before I can accept that plea, I need you to tell me what you did that makes you guilty of that offense. Turning your attention to May 2nd of 2000, I'm sorry, why did I say May? That's because today's May.
Yeah.
And today's my anniversary, so I got it in my head. By the way, I did not forget. All right?
Let the record
Let the
reflect.
record reflect, I did not miss my anniversary. Any man is out there, the key is to make your anniversary a part of any password Now, don't get surprised like I'm giving you my password, but I used numbers in a certain place, but anyways. All right. So, on that, September 2nd of 2025, up in Springville Township, which is up by Mesa here in Wexford County. What happened? Looks like were you stopped by a police officer?
Yes, I was pulled over. Check my heart.
And did you know it was there? And did you know it was methamphetamine?
Yes, sir.
What was it found in?
Yeah, it was amazing.
A magnet? Could you actually see a little bit of the crystal substance on there?
No,
No? Was it inside?
yeah, it was in my car.
Oh, I see. I got it now. But you knew it was there and you knew that it was methamphetamine. Is that right? And in your mind, did you have any lawful right to possess that controlled substance? And is it also true that on or about February 7th of 2025, you were found guilty of possession of the controlled substance methamphetamine in another court? Or maybe it was this court. All right, thank you. Oh, wait, I see that. It was in Wexford County. I see that down below. All right. Thank you. Ms. Dahl, do you believe the defense provided a factual basis?
Yes, Your Honor.
Are you aware of any other promises, threats, inducements?
None.
Do you believe I comply with court rule 6.302?
I do.
Mr. Harrison, do you agree?
I do.
The court agrees and finds the defendant plea was made freely, knowingly, and voluntarily. The court specifically finds that her testimony provided supported the greater offense and pursuant to court rules and case law, the court is allowed to and hereby does accept that plea to the use. Therefore, the defendant is found guilty of added count 2, use of methamphetamine as a subsequent offender. The remaining original offense and other enhancement will be dismissed at the time of sentencing. This case will be set for sentencing. We typically do them on Monday mornings in about a month from today. And between now and then, an agent from the Department of Corrections has to prepare a pre-sentence investigation report. That report will include a description of the offense, description of the pretrial agreement, any statements or information you may provide. It will also include information about your prior criminal history and performance on bond and probation, which is extremely important to me. And it will also make a recommendation as a sentence. Please keep in mind it's merely a recommendation. And it will also include a scoring of the sentencing guidelines, which again are not mandatory, but the court must consider them. There are 3 steps that involve you. When you leave this courtroom, you're gonna go downstairs to their office. I assume you know where they are because you had a probation violation copy. They're gonna give you a packet like they probably did last year. You're gonna complete it, turn it back in. You'll be subject to an interview with an agent and you have the right to have Mr. Harrison present. And Mr. Harrison needs to make sure he has contact with you as he will make sure you know when you need to go back to court. And he will meet with you and go over that report prior to coming back for sentencing. Do you understand? All right. Any questions of me today? All right, thank you. If you're not getting any treatment, please ask Community Corrections. They can help you get some if you feel that it's
I
appropriate.
have.
Good. I'm glad to hear that. That's very, very important to me.
10 months, I'll be too.
People always come in and ask for rehabilitation. I don't have a list of beds available here. The state doesn't give them to me. So when people go out and find them and take advantage of them through whatever channels they can, it's very helpful. All right. Thank you very much. Ms. Dahl, any objection to the continuation of bond?
No objection.
Your bond hereby continues. Anything further, Mr. Harrison?
And Mrs. Stoll?
Thank you very much. We'll see you in about a month, man. Don't forget to go downstairs. All right, what we got next there, Samantha? Oh, looks like we're gonna jump over to Massachusetts County. All right, we are back on the record now, but this time we're 28th Circuit Court for the great county of Massachusetts. And the file here is People of the State of Michigan versus Megan Jean Salsbury. There are actually 2 case numbers here. The numbers are 24-3494FH and 24-3508FH. Appearances from counsel that are appearing today via Zoom.
Thank you, Your Honor. David Houghton on behalf of the people.
Robert Hotel is Ms. Salsbury, who joins us from the Zoom from the jail, Your Honor.
All right, thank you, Ms. Salsbury. Are you able to see and hear the court?
Yes, kind of.
Thank you.
A little bit echoey.
I'm sorry, could you repeat that?
It's a little bit echoey, but yes, I can hear.
Oh, it is accurate. Let me see if we can figure that out. And when I say we, I mean somebody else.
The courtroom is not muted, so I think it should be fixed now.
Let's mute the courtroom over there in the socket.
I think everything's fixed now.
I don't know. I still hear an echo.
You hear it through Nancy's headphones.
Oh. Anyways, all right, we're here. Mr. Luke Blazek is also here. He's the probation officer on these two files. Ms. Salsbury, I need to tell you that we're here today for an arraignment on some alleged probation violations.
Your laptop.
I know.
You gotta turn your volume off, right?
Yeah.
Did that fix it? Ms. Salsbury, can you hear me still?
Yes, I can hear you.
Okay, great. Each one of these files include a request and warrant for a probation violation. Looks like there was an initial request filed by Mr. Blazak initially back on October 7th of 2025, and I signed it on October 8th. And then after that, Mr. Blazak submitted a amended requested warrant that included those two original counts, but added 4 others. And they are the same in each of the two files. Count 1 alleges you violated condition 1 of your probation, which required you to report to your probation officer as directed and allegedly on or about July 15th of 2025. You failed to report and your whereabouts remained unknown until you were arrested. Count 2 alleges that that alleges a violation of condition 4.16 that requires you to obey all court orders. And more specifically, it's alleged that on or about August 8th of last year, you failed to appear for a request and summons for that initial probation violation. Count 3 alleges a violation of condition 2.4. In fact, counts 3, 4, 5, and 6 all allege violations of condition 2.4. That condition requires that you are not to use or possess any controlled substances or drug paraphernalia. For count 3, it's alleged that on or about May 14th of this year, you used methamphetamine as evidenced by a positive drug test. Count 4 alleges that on or about that same date of May 14th, if I said March, I'm sorry, it's May 14th, you used cocaine as evidenced by a positive drug test. Count 5 alleges that on that same date, again, May 14th of this year, you used fentanyl as evidenced by a positive drug test. And count 6 alleges that on that same date, you had used buprenorphine, also evidenced by a positive drug test. You have the right to challenge these 6 allegations in both of these two files and have a contested hearing. That hearing would be conducted within 14 days from today's date, unless both you and the prosecutor waive their right to have that hearing conducted within those 14 days. You have the right at that hearing to have the prosecutor prove the allegations by a preponderance of the evidence. You also have a right to be represented by an attorney at that hearing and all subsequent proceedings. If you cannot afford an attorney, the court may, if you ask, appoint an attorney to assist you and or to consult with before and at a hearing. At the hearing, you'd have the right to review the evidence against you, question, cross-examine any of the witnesses presented against you. You have the right to present witnesses, evidence, or testimony if you chose to do so. And you'd also have the right to remain silent and not have that silence used against you. Now, if you're found to be in violation of your probation, you'll be resentenced on your original offenses. In the first file, file number 3494, you were convicted of the offense possession of the controlled substance methamphetamine. That's a felony punishable by up to 10 years and or up to $15,000. In the other file, 3508, you were convicted of introducing or bringing into a jail contraband. That is itself a felony and punishable by, I think it's up to 5 years. Let me get it for us. Yes, up to 5 years and or $1,000. Now, of these 6 counts, some of them are technical violations. Now, one of them, or 2 of them are counts 1 and 2. Those were the failure to report to your probation officer and the failure to report for the summons. Now, those were technical violations, but because you've been in an absconder status, they now, for more than 60 days, they now become non-technical. For non-technical violations, the court is not limited to a sliding scale of additional confinement. It is only limited by the allowance allowed under the law for the original offenses of which you were previously convicted. Now, the other counts, 3, 4, 5, and 6 are technical violations. Now, for technical violations, the court is limited to 15 days for one, 30 days for a second, 45 days for a third, or would not be limited to a sliding scale if there were 4 or more. So it depends on which ones you were found guilty of that would limit or contribute, would lead the court to determine what should be done for sentencing. Now that I told you what the charges are in each of the 2 files, what your rights are, and the possible consequences, I need to see how you wish to respond. I should also say that probation violations are not considered new criminal offenses, and therefore the person is not entitled to a trial, at least as they are alleged as probation violations. Now that I've told you all that, Ms. Salsbury, I need to ask the question. Do you wish to hire an attorney, plan to hire an attorney, or do you wish to have the court appoint an attorney to assist you?
I have Mr. Hartel assisting me, I believe.
Yep, that's Mr. Hartel, and he's in the courtroom. And I know he's there, so I'm just going to ask Mr. Hartel, have you agreed to take on this case and continue to represent Ms. Salsbury? Okay, I can't hear you. Just shake, just give me a thumbs up. Yes, he said yes. All right, there we go. Congratulations, it's like a proposal. All right, so the court will enter not guilty pleas on behalf of the defendant. The court will accept Mr. Hartel as defense counsel. And we'll still need an appearance filed by Mr. Hartel. Ms. Salsbury, are you on probation or parole anywhere else at this time?
No.
All right, thank you. All right, Mr. Hartel, there's no pressure. I'm just asking since you were already there in the courtroom. Do you have an idea of what we're doing today, or should I just set it for a informal hearing?
Thank you, Your Honor. I believe I started to say it before, but I may have been muted at that point. We have had discussions with the people in the probation department. On both these files, my client would be willing to plead counts 1 through 4, and then they would be dismissing counts 5 and 6.
All right, hold on. I'm going to repeat that. I'm going to see if actually I might ask I'll ask Mr. Denhout first. Mr. Denhout, do you agree that she's going to plead to counts 1 through 4 and the people will dismiss counts 5 and 6?
That is correct, Your Honor. Additionally, there is a recommendation for 365 days jail and termination of probation. However, that's a recommendation and not a Killebrew agreement, Your Honor.
Thank you. Mr. Hartel, did Mr. Denhouten recite it correctly? All right, we need the volume again.
Hang on just a second.
Sorry there, Ms. Salsbury. It's not intended to be punishment that echoes. All right, Mr. Hartel, did Mr. Denhouten state it correctly?
He did state it correctly, yes, Your Honor.
Great, no echo. All right, Ms. Salsbury, is that how you wish to resolve this today?
I guess because
Hold on.
one thing I don't really fully agree with is the count 6 is my own medication that's in my body, but.
Oh, hold on.
Yeah, yes, today. Yeah.
That's okay. All right, Miss Salsbury, I'm gonna swear you in. But when I do, then I'm gonna go over the terms of the agreement, and then I'll ask you if that's correct. I think there might be a misunderstanding. Please raise your right hand for me, ma'am. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth, Miss Salsbury?
Yes, sir.
Thank you. You may lower your hand. Miss Salsbury, first of all, do you need me to repeat to you what those 6 counts are?
No, sir.
All right. You mentioned count 6. Count 6 is being dismissed. That's the buprenorphine.
Yeah.
All right. And then count 5 is being dismissed as well. And count 5 is the fentanyl.
Okay.
So you would be pleading guilty to not reporting to your probation officer, to not appearing for a summons or court order, for testing positive for meth, and for testing positive for cocaine. And once again, those last 2 counts will be dismissed. Is that what you understood?
Yes, sir.
Now, I saw you shake your head when Mr. Denhoughton talked about a recommendation for sentencing. Now, I accentuated that word recommendation for a reason. It's merely a recommendation. It's not what we would call a kilo brew agreement where if I don't follow it, the person has the right to withdraw the plea. Mr. Denhoughton has just agreed to say that he, and I assume the probation officer, are going to support or recommend to me up to 365 days, or at least no more than that. Do you understand?
Yes, sir. I understand.
Okay. All right. Got it. Mr. Hartel, I got that correct. Am I right?
You are correct, Your Honor.
And Mr. Denham, I'm just confirming one more time.
The court has it exactly correct, Your Honor.
All right. Now, Ms. Salsbury, have there been any other promises, threats, or inducements to force or compel you to make these admissions today?
No.
Are you doing so of your own free will?
Yes, sir.
Thank you. All right, Ms. Salsbury, as to counts 1 through 4, how do you plead?
Guilty.
Thank you. In each of these 2 files, the court takes judicial notice of the terms and conditions of probation that were issued by this court and then subsequently acknowledged by the defendant, and they are contained in the court files. Ms. Salsbury, is it correct that you failed to report back on July 17th and then just never reported again?
Somewhat, but not for lack of trying. I had been living in Elma and with my daughter and son-in-law. We started having problems with my son-in-law, and he kicked us all out with a couple hours notice. But I had been telling my probation officer for weeks up until this point that he was going to be kicking me out and I wasn't gonna have a place to go. He kicks me out. I go to Saginaw, where I had the only place I had to go at that time, with my daughter, youngest daughter, or whatever. Call my probation officer before my report date and tell her I needed transferred to Saginaw. She said she could not transfer me unless she seen me in person. I had no vehicle to get an hour away to go see her. I told her that. She gave me 2 more days. I tried to find a ride in those 2 days, couldn't find it. So there was the first violation.
All right. And so you also didn't show up for a show cause summons for that alleged violation. Is that correct?
That, yes, because I had no idea it even came, because it would have went to the house that I was living at, that I got kicked out of by my son-in-law, but yes.
All right. Thank you. All right. Is it also true that earlier this week on the 14th, well, actually that would have been last Thursday, that you were tested for methamphetamine and tested positive for methamphetamine because you had used some?
After I was found to be absconding, I also lost my mother, a grandchild, and an uncle in a very short amount of time, and I went off the rails, and yes, I used.
Okay. Is it also true that you tested positive for the controlled substance cocaine because you had ingested or used some cocaine?
Yes, for the same reason.
All right. All right. Thank you very much. Mr. Denon, do you believe you provided a factual basis?
Yes, Your Honor.
Are you aware of any other promises, threats, or inducements?
No, Your Honor.
I believe the court's compliance with the court rules.
I do, Your Honor.
Mr. Hartel, do you agree?
I do, Your Honor.
The court agrees and finds the defendant's pleas today are made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath satisfies the required elements of proof for counts 1, 2, 3, and 4. Counts 5 and 6 are hereby dismissed. I will make a special finding as to count 2, which of course there was a defense of her saying that she did not know she had to because she couldn't receive the notice. However, the court makes the note that that's why in the probation terms and conditions, Ms. Salsbury is required to let a probation officer know where she can have mail sent to know it.
I did
Yes.
let her know where my address was. I did tell her the new address. So she was well aware, so was another courthouse.
I'll tell you what, because it's not going to matter. The court will dismiss count 2, find her not guilty of count 2. She's already found guilty of 1 non-technical and guilty of 2 technicals. It doesn't change the potential punishment range at all. All right, Mr. Blazak, can we proceed to sentencing?
Yes, Your Honor.
Mr. Hartel, any objection to proceeding to sentencing now?
No, Your Honor. When I met with my client earlier, she had expressed an interest to do so today if possible. Thank you.
All right, Ms. Salsbury, is that correct? You are agreeing to allow us to proceed to sentencing and use Zoom today?
Yes, sir.
Thank you. Mr. Denhout, any objection?
No objection, Your Honor.
All right, go ahead, Mr. Blazak.
Yeah, she was initially sentenced in both files to 2 years of probation. She had 156 days jail credit in the 3434 file, and excuse me, let me begin that order. She was initially sentenced to 2 years probation in both files. For the possession of methamphetamine, the guidelines were 0 to 17 with a maximum exposure of 10 years. For the contraband into prisons, the guidelines were 2 to 17 with a maximum exposure of 5 years. There were no previous violations. However,
how much credit does she have?
Currently, as of today, she has 164 days credit in file 243494, and she has 105 days credit in file 243508.
All right, thank you. Your recommendation, sir?
The recommendation would be for 365 days jail and termination of probation. Her poor previous performance on probation and other community supervision was discussed in pre-sentence investigation for these files. She was given an opportunity on probation and to go to treatment program. They asked her to leave the treatment program in November of, I believe it was 24, but so sometime after she was there, she did continue with treatment outside of that, but she was asked to leave because of curfew violations. Just appears to continue to have problems being compliant with supervision. So again, the recommendation is that 365 and terminate both files.
Mr. Denhout? Thank you.
Your
Mr.
Honor,
Denhout?
Your Honor, the people support the recommendation. Appreciate the frankness that Ms. Salsbury gave regarding her difficulties. However, supervision has just been somewhat difficult at this point. So I think it is appropriate for a straight jail sentence at this time. And again, I support the recommendation.
Mr. Hartel?
Yes, Your Honor. I would ask the court to adopt the recommendation, or if the court felt comfortable even going perhaps slightly lower than that, as the court did note with the recommendation and not a killer, the court could go above or below. I'd ask the court to not go above it at a minimum. For context, just so the court knows, if you saw me looking behind me a few times, my client's grandmother is in the courtroom for moral support. She advised me she's fine with me pointing that out. I only mention that to say that there are people in the community who are still rooting for her, who still love and care of her. I was informed there might be other family members who will watch this later. They couldn't be here in person because they have jobs, obligations, adulting, basically. But what I will say is, I know my client admitted to quite a bit. She did explain some of the reasons, but there's a difference between an explanation and excuse. She and I have exchanged conversations on that. She, however, does want to make sure that she is successful moving forward. I do believe it's appropriate to terminate the probation. She's realistic that the court is almost certainly going to give her some jail time. With the moral support she does have, I am very hopeful that when she is eventually released, that we won't see her back in the system again. I'd ask the court not to go above that recommendation. Thank you.
All right, Ms. Salsbury, you have the right to make a statement before I issue a sentence. Is there anything you think I need to consider today, ma'am?
Yeah, the treatment center he's talking about that I got kicked out of was not one I was sent to by you guys. It was sober living I went to on my own after the treatment center that I was sent to. Not that it makes a huge difference, but if you're even 2 minutes, you lose your spot there. So I did. And then I moved, and I did very good still, even after I left there. It wasn't like I just left there and messed up. I did very good on probation up until the point of, the move happening and me getting violated. And then I found out my mother had cancer and she passed away very quickly behind that. And so I lost a little bit, but I'm dealing with my stuff. It'll be better after this, otherwise I don't have anything else to say, no.
All right. Well, I'm going to point out a few things, and when I do so, it's not about me as a person. What Jason thinks isn't that big of a deal, but I'm ready to point it out to you because somebody needs to say it. Every time, and I know you entered a plea today and you did so, but everything you've somewhat admitted to today or even brought up, including the information about a rehab program that you went to, also always followed up with an excuse. There aren't any excuses that say, I'm going to go out and use methamphetamine, and while you didn't plead guilty to it, fentanyl, mix it with buprenorphine and have cocaine in your system. You may have had buprenorphine as a medication, but you're taking that medication and prescribed that medication because it is a semi-synthetic opiate that's designed to help you wean off of opiates. So I do not have, and I really wish I did,
Was it here?
confidence that you're going to not be back here.
All right.
I don't know if you are on the right track or not, but all I know is that everything you admit to also comes up with an excuse. You don't have an excuse. Nothing you said about the troubles in your life, passing away of a family member, as an excuse to go start doing drugs again. I don't know if you're, well, hold on. Let's try to not talk right now because I guarantee you it's not going to help you. I'm just talking and this is my turn. And so my turn is, Ms. Salsbury, I don't know why I don't send you to prison. That's really my question. Mr. Hartel wants to ask and talk about, well, I should go below, and I appreciate his request to do so. That's what he's supposed to do, and he made a good argument, is doing a good job. I don't know why I don't just send you to prison. It's the same story every time. Stop hanging on to excuses. All right? I don't care. They're falling flat on anybody else outside of you. Now, I don't say that to be rude or be a jerk. I'm trying to get you to stop doing that. I want to encourage you to stop doing that. Now, if I don't send you to prison, my second question is, why do I not keep you on probation and wait to see if you screw up again? Knowing that I will max out your jail time. And then the next time, if you do violate, the only place left for me to send you is prison. So that's the second question. So I'm still thinking. Well, the court sentences the defendant as follows. The court, and by the way, the court's only supposed to use probation when it thinks the person won't reoffend. Well, the court terminates probation without improvement in both of the two files. In file 3494, the court also preserves all fines and costs within the two files. Madam Clerk, were there any payments? Other court clerk, sorry. Over in Misaki?
No.
All right. So you've done nothing. You haven't done anything right. Probation does not work for you. That's the message you're telling any judge, including me, if you ever come before us. Probation is no longer a really good option. Court, again, preserves all fines and costs, terminate probation without improvement, and sentences the defendant to 365 days in jail. And in file 3494, she gets 164 days of credit. In file 3508, she gets 105 days of credit. They are to run concurrently, of course. So, Ms. Salsbury, I really, really hope you figure this out. I really hope that when you get out of the jail, that while you're in the jail, you talk to Catholic Human Services, talk to Ms. Platts. I really hope that when you get out, you continue your treatment and communication with Ms. Platts and Catholic Human Services. I hope that you try to use their services and try to get into a treatment program like an inpatient or outpatient. Otherwise, when I see you come back here again, I'm going to be really worried about you. And I'm going to realize that nothing can keep you away from drugs if you keep going back to them. And the next place to send you is just into prisons. That's where people need to go if they keep doing the same thing over and over again, and they can't comply with probation and they can't get treatment. They are telling a judge like me, Judge, I need, even though the words won't come out of your mouth, I must be sent to prison. It's up to you. You have the right to appeal your conviction and sentences. And because of the plea in this case, any appeal is done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the document that will be provided you in the jail on each of the two files. If you choose not to appeal, you may simply dispose of your copy of that document. You've got people here who care about you, but I can tell you as somebody who has dealt with addiction in his family, that stops. Love might be unconditional. As we say in our house to our kids, our love is unconditional, but our money, our time, our house, it's got strings attached. We're adjourned. Of course, I got it wrong. Jackson. Court recognizes both counsel reappearing and Mr. Jackson also appearing. Had a couple minutes to talk in chambers with counsel, and they demonstrated a good cause to adjourn the file. We aren't near the 180-day speedy trial clock. The charge, the defendant was arrested on February 18th. And there are some discovery issues, which anybody who watches too much TV and thinks, oh my gosh, you should have body cameras for everything. Well, they do, but it takes literally a day to download one body camera onto a file. So we've got some time issues, so I appreciate that. So the court will grant the request to adjourn. I'm going to contribute it to both parties because both parties agreed they need to coordinate some discovery. And apparently there might be another video that had not been known about earlier. Anything further to add to that, Ms. Carey?
No, thank you.
Anything further to add to that, Ms. Vandenberg?
Nothing further, Your Honor. Thank
All
you.
right, thank you very much. Any questions, Mr. Jackson? All right, go ahead, and if you do have to talk to your counsel, thank you very much. We are adjourned.
Thank you, Your Honor.
Yes, ma'am. Our next file is going to be People versus Richard Faylor, file again, 2514164FH. The court recognizes the appearance of the both counsel again, as well as Mr. Faylor. We spoke in chambers, and I understand the reason for the request. I think it's fair. There is good cause to grant the request to adjourn this case. That allows the prosecutor and the defense to continue their negotiations, and therefore the court will find good cause. Again, in this file, we are beyond the 180 days, but the defendant's not in pretrial custody, which means if it is in pretrial custody, it goes straight to the top for trial duty, and therefore I don't find any prejudice. And I attribute the delay to both parties. Anything further to add, Ms. Carey?
No, thank you.
Anything further to add, Mr. Harrison?
Nothing further, Your Honor. Thank you.
All right, thank you. Mr. Faylor, feel free to talk to Mr. Harrison. Thank you very much. We are so adjourned. And by the way, I'll set it out for 2 more months. If you all wish to come and say, hey, Judge, explain again what you're looking for. I'm very, very reluctant to sign any requests to adjourn unless it's detailed. And if you don't want to detail it in some files, which I completely understand, come and talk to me. Thank you very much. We are adjourned on that file.
Very good, Chief.
And our next file is People versus Laura Webster, file 2614193FH. We've got the parties approaching, as well as Miss Webster. Again, we went in chambers, the parties and I talked about the case. Apparently there is some issue with the labs. And again, if you think anything on TV is halfway correct, you are 100% wrong, because it takes us a long time to get lab reports. This file isn't at the 180-day speedy trial clock window. It's getting close, but the defendant's not currently in pretrial custody. Therefore, there's no pressure to get the case to trial right away. And plus, the court finds the excuse for good cause, and the court attributes the delay as to both parties. Anything further to add, Ms. Dahl?
No, Your Honor.
Anything to add, Mr. Harrison?
I do not, Your Honor. Thank you.
Thank you very much. We are adjourned. And now. All right. We are next taking up the case of People of the State of Michigan versus Amanda Tingay? I'm sorry, ma'am, if I mispronounced it. Amanda, how do I pronounce your last name?
It's Amanda Tingay.
All right, Tingay, thank you. Ms. Tingay appears this morning via Zoom. I recall last week, maybe earlier this week, my office asked me if she and her counsel could appear via Zoom. Her counsel is Mr. Haraya Nagos. Mr. Nagos appears via Zoom. Sir, can you see and hear the court?
Good morning, Judge. Thank you.
Thank you. Appearance from the people.
All
right, thank you very much. Looks like we're here for a plea. The court just issued on May 5th its scheduling order. I have a copy of the pretrial agreement here. I'm going to go over it. Is that what we're still doing, Mr. Nagos, is entering a plea?
Yes, Your Honor. Thank you.
Thank you very much. All right, Ms. Tingay, is that, you understand you're here to enter a plea, is that correct?
Yes.
I should look at the camera. All right, Ms. Tingay, please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may lower your hand. Ms. Tingay, looking back on April 24th of this year, wow, this case got here quickly. Were you on probation, parole, or bond at that time?
No.
Thank you. You are currently charged on a felony information with a single count. That count is for carrying a concealed weapon. That is a felony punishable by up to 5 years and or up to $2,500 plus mandatory forfeiture of the weapon or device. All right, and that I'm told today that you're going to enter a plea of guilty to that count. Now, if you do, and I accept that plea, I'm told that there's an agreement as to sentencing. Now, that sentence is what we call a kilobrew agreement, which I will explain in just a moment. That agreement is that you be placed upon a delay of 3 months. And if you are successful with that delay, the people will then dismiss the file. Is that what you understood so far?
Yes.
Now, that dismissal does not entitle you the return of the weapon. Do you understand?
Yes.
All right, good enough. Thank you. Now, I told you that this is a kilobrew agreement. Now, there are a couple different ways to enter agreements in a Michigan court as to a sentence. One of them is where there's like a dotted line between the prosecutor and the defense. And that dotted line means it's not really binding. It's just that the prosecutor agrees to recommend to the court a sentence. Well, that's not what's happening here. The second type is what we call a Cobb's agreement. That's where there's like a binding line between you, the prosecutor, and then the court. It's like a triangle. And that means I would agree to the sentence today. I don't do those sentences. I don't think they're appropriate because I don't know anything about you. When we get back here for sentencing in about a month, somehow the probation office who prepares a report, they might be able to tell me that they have actually finally discovered that you were involved in some kind of terrorist plot. I don't know if that's true. I don't think it's true, but that's the reason I don't do it, because I don't know anything about you. So this is what we call a kilobrew agreement, which means at the time of sentencing, if I do not go along with it, you would have the right to withdraw your plea and come back to this stage of proceedings and then continue negotiating. Do you understand?
Yes.
All right, good. Now, I have here a written copy of this pretrial agreement, and it appears to have a signature for you. Did you sign a pretrial agreement or allow a counsel or somebody to sign it for you?
Yes, I did.
All right. Did you go over the terms of this agreement with your counsel, Mr. Niegos?
Yes.
And was he available to answer all your questions, talked about your options, talked about going to trial, talk about what witnesses to call, things like that?
Yes.
All right. And so the key point here is, has he been accessible enough for you that you're satisfied with his representation as of at least till today?
Yes.
All right. Thank you. Now, if you enter a plea of guilty today, you're not going to have a trial. Does that make sense?
Yeah.
All right. If you enter a plea of guilty and I accept that plea, you'll be given up the right to be tried by a jury, the right to be tried without a jury if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for your defense to appear at the trial, the right to remain silent in the trial, and the right to not have its silence used against you, and the right to testify if you chose to testify. Do you understand those rights, Ms. Tingay?
Yes.
Do you understand that if you enter a plea of guilty and I accept that plea, you'll be waiving those rights as it applies to this particular case?
Yes, I do.
You also will be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record. Have there been any other promises, threats, or inducements to force or compel you to plead guilty that we have not yet discussed?
No.
All right. Are you entering the plea of your own free choice then?
Yes.
Has anybody made any promises to you? That includes Mr. Niegos, about exactly what the sentence would be?
No.
I would do. All right, good. Do you still wish to enter the plea that we discussed earlier?
Yes.
As to count one, possession of or carrying a concealed weapon, specifically a pistol inside of a 2010 Chrysler Town and Country. How do you plead?
Guilty.
Now, before I can accept that plea, I need you to tell me what it is that you did that makes you guilty. Turning your attention to April 24th of 2026, in South Branch Township, which is out in the western half of Wexford County here in Michigan. What happened? Were you stopped driving a vehicle?
I was the passenger in the vehicle.
All right, and did you have on you or in your possession a pistol?
I did. I brought a pistol, yes.
All right, and did you have a concealed pistol license to be able to lawfully carry that in a motor vehicle?
No, sir.
I should ask this, was it loaded?
No, completely unloaded with nothing in the chamber.
All right, but it was inside the passenger compartment. I can take judicial notice that Chrysler Town and Country is a minivan, so the whole thing is it's not like you have a separate trunk. Would you agree?
Yes.
All right, thank you very much. All right, Ms. Lawrence, you believe the defense provided a factual basis?
Yes, Your
Are
Honor.
you aware of any other promises, threats, or inducements?
No, Your Honor.
Do you believe the court's in compliance with the court rules?
Yes.
Mr. Neos, do you agree with all three?
I do, Judge, and just briefly, hopefully the court has a copy, and I appreciate the court going over the advice of rights in the detailed manner it did. I also provided your staff with the signed advice of right copy. I just wanted to make sure that you had it on file.
I did, I have it, but I often show it to the person, and I didn't know if she could be able to see it because she might be on an iPhone, so that's why I didn't, but I thank you very much. All right, so the defendant's found guilty of count one. The case will now be set for sentencing. Ms. Tingay, we do sentencings every Monday morning. I can predict that yours will be in about 4 weeks from this coming Monday. Between now and then, agent of the Michigan Department of Corrections is going to need to give you a packet that you're going to complete and turn in. It's going to ask you, because I need this, they prepare a report, and that report will tell the court about the pretrial agreement, the facts about the case, information about you, any prior criminal history, if you have any. It will also include a scoring of the sentencing guidelines, which are not mandatory for the court to follow, but the court must use them and take them into consideration. It also will make a recommendation as to the terms and conditions of any probation and or sentence. However, whatever they offer is strictly a recommendation. So I told you you're going to get a packet. I need to make sure, is your address still this one at Kosciuszko? K-O-S-C. Thank you. I've never gotten that anywhere near correct. All right, thank you very much. And I'll make sure they know how to get a hold of you there. They're going to send you that packet. You're going to complete it, turn it in. They're also going to require an interview with you, and you have the right to have Mr. Negos present during the time of that interview. And Mr. Negos will need to go over that report with you prior to coming to sentencing. Each side will probably get that report in about 10 days, maybe 2 weeks before coming back here for sentencing. And while I told you we'll be back here in about a month, sometimes in the summers, it might be 6 weeks. We'll see. All right, any questions of me?
No, sir.
Ms. Lawrence, any objection to continuation of bond?
No, Your Honor.
Bond hereby continues. Anything further, Mr. Negos?
No, yeah, thank you.
Thank you. We're adjourned.
Have a good weekend, Judge. Thanks, Courtney.
All right, take care.
You know.
Yeah. I know. All right. Our next file is People of the State of Michigan versus Christy Tucker Fleischfresher. File number is 26-1420, 14250 FH. Appearances from counsel.
Good morning, Your Honor. Brendan Maturin for the people.
Jerry Faber, P67547, on behalf of Ms. Tucker Fleischfresher.
Hi, and Ms. Fleischfresher is here. You all may be seated. Mr. Maturin is appearing here as an Assistant Attorney General. He's appearing today via Zoom. And here today is this initial pretrial conference.
It was the bail for the bond motion.
All right, yep. All right, so we're here today for an initial pretrial conference. The court has received a completed criminal joint pretrial conference report. I received that. Looks like discovery is complete with pending some potential expert reviews. All right, thank you very much. Those are inside the file. Here in the case, the defendant's currently got some significant charges here. And so this is the first time this case has appeared in front of the court. The court issued its pretrial conference scheduling order on April 30th after the case was bound over from the 84th District Court. All right, so first of all, we have no resolution. Is that correct, Mr. Maturin?
That is correct, Your Honor.
Thank you. All right, so we are now complete with the pretrial conference, but now we're here today for a defense motion to modify and remove electronic tethering devices. I turn it over to Mr. Faylor.
Thank you very much, Your Honor. Your Honor, Ms. Tucker is 40 years old. She has absolutely no criminal history. She has lifelong ties to Wexford County. She owns property here. She owns a business here. When she was informed of the charges filed against her, she was out of state across the country. She immediately voluntarily returned to Michigan to face these charges and turn herself in. At the arraignment, there was some discussion about a planned vacation, a cruise that was to occur in April. And I believe Judge Wiggins at the time, because of that discussion, had imposed an electronic tether as part of the bond condition.
Okay.
That trip was canceled. Ms. Tucker has appeared for all scheduled hearings. She is in constant communication with retained counsel. She is absolutely not a flight risk. She is not a danger to the public. The preliminary examination was held, even if the court took the case in the light most favorable to the prosecution. This case does not involve an act of commission. It would be an act of omission, and it is a defensible case. I would just put that on the record. The defense is humbly requesting that the tether is not necessary with all of these facts. It is an unnecessary burden and expense to Ms. Tucker. She is not a flight risk. She is eager to defend this case and will appear for all scheduled hearings. We're asking that bond condition be removed. Thank you.
All right. Thank you. Mr. Maturin, your response on behalf of the people.
Judge, everything that Mr. Faber said is accurate as far as I know. Indeed, the defendant has appeared in court every time she was asked to do so. I don't believe she's a danger to the community. I don't believe that she's a significant flight risk. Obviously, she is facing a fairly serious charge in count one. The same request was made to Judge Wiggins when we were in district court, and he denied it. He didn't really elaborate on his reasoning. I don't really strongly object to the request. Obviously, the people's interest is in having the defendant appear in court and answer to the charges pending. There is another condition. It hasn't been raised, but I would ask that if there are any modifications made to the bond, one of the conditions is that she's not to be actively involved in resident care at Pleasant Lake Lodge, which is the facility where she, I believe, is still currently the administrator. And I believe her family has an ownership interest in that facility. I think there's a bond condition, like I said, that she is not to be involved in direct patient care to the extent that she can be involved in administrative activity with running the facility without being involved in patient care. I don't have a problem with that. That's all I really have to say, Your Honor. Thank you.
The bond condition that you mentioned says no foster care or medical services directly.
Yes, Your Honor. Correct.
All right, copy that. All right, thank you very much. Mr. Maturin, do you have any prior criminal history information that might be helpful? I don't, if I remember right, that was mentioned. Oh, disregard. That was covered on page one. I'm sorry, I noted it. All right, so she's got no prior criminal history of any kind, correct?
That is correct, Your Honor.
And thank you. Strong, lifelong family ties. Tell me about that. Did she live here the whole time? Tell me.
Yes.
All right. And I will note it says no impact on this, but I grew up out by the Pleasant Lake Lodge, and my grand, I remember there used to be a bed and breakfast long time ago. It was the only building out there. I think my grandfather used to play piano there. My family owns most of the farmland around. That didn't have any impact on me though, since we don't anymore. All right. What took her to leave out of state? Like she was living elsewhere? Tell me about that.
It was just a family vacation that happened to coincide with the issuing of the charges.
All right, got it. All right, thank you. So it's not like she moved to another place.
Correct.
You go by Vice Webster, what would you like me to call you? Tucker? I want to make sure I call you by the right. Do you have a passport?
I do.
All right. The court will modify the bond to remove the condition of the tenant. The court, however, modifies the bond sua sponte further to require that she is to forfeit her passport to the community corrections office for holding. That will help eliminate her ability to leave the United States. All right, I think that's fair. Anything else, Mr. Maturin?
No, thank you, Your Honor.
Anything else, sir?
No, thank you very much, Your Honor.
Thank you. We're adjourned. Hold on, Madam Clerk, we're going to say that she must surrender the passport at the same time she has the ankle monitor taken off. Thank you.
Thank you very much, Your Honor.
Our next file this morning is people in the state of Michigan versus Brooke Renee Halliday. The file number here is 25-14132FH. Appearances from counsel.
Nate Carnes on behalf of the people.
And
I am Jeff Peterson. I am assigned to Ms. Halliday's current matter before this court.
And Ms. Halliday appears this morning via Zoom from the Webster County Jail. Ms. Halliday, are you able to see and hear the court?
I'm sorry, what?
Are you able to see and hear the court?
Yes.
Thank you. All right, Ms. Halliday, we are here today for an arraignment here on a show cause. Actually, I take it back, a bench warrant, because you've been apprehended by, looks like through community corrections. I need to tell you what the allegations are, what your rights are, and your possible consequences, and see how you wish to respond. It's alleged here that you were released from Grand Traverse County Jail while the court had you remanded, and the Osceola County had a bench warrant for your arrest. So were we on the record? Yes, sir.
So Your Honor, she's already has a remand in this file. It's kind of unique. There is new criminal behavior. She was found in possession of drug paraphernalia, but she's already remanded. So.
Oh. So she had Grand Traverse County Jail, just didn't check lien.
Correct.
That's my understanding. Yes.
Huh.
Yep.
All All right. And she's got a bench warrant from Osceola as well, so we can't release her either. So has she, in this file, take a look, you said she was remanded?
She was remanded at the plea.
Oh, yes.
Guilty, you revoked bond, set for sentencing in a couple of weeks. We already have the
On June 8th.
Really wanted to participate in that conversation. Sorry.
Yep, no, you're going to. You're gonna get your chance. All right, 1 second. So, looks like she was arraigned. All right, so we had dealt previously with a petition regarding bond for an alleged bond violation. The court initially issued a bench warrant on October 16th of 2025. Then she appeared before the court on March 6th after being apprehended on that warrant, or at least we discovered she had been in Grand Traverse County Jail. Then on April 17th from the Grand Traverse County Jail, she entered a plea of guilty to being a felon in possession of ammunition. And is that it?
That was it, is my understanding.
Yes, sure.
Wow. All right, and we have sentencing scheduled for June 8th. All right, Mr. Harrison, you said you wanted to speak, and I know we want to get that on the record.
I just wanted to nail down a couple of the details that I believe have been covered at this point in time. It's our understanding that there remains an open bench warrant out of Osceola County, or is it Mecosta?
Osceola.
I often get them confused, so they're the same place to me.
They're both under us.
And
south.
That she was remanded in this case with a sentencing date pending in front of the court, as you've already noted. So I don't really have anything material to add.
So you wanted to talk and just repeat everything I said.
I think that was the case, yes.
That's okay. All right, so Ms. Halliday, we have you still set. We're gonna still continue to have you set there because I already remanded bond. I don't have any motion to modify bond. And you also wouldn't be going anywhere anyways because Osceola County has a hold on you. So, and I do remember that more than likely the last time I remanded her because I knew she had the case in Grand Traverse, had the case in Osceola, had the case here. And so
she was incarcerated in Grand Traverse up through and including, I think, until the day before yesterday or something crazy like that.
Well, I'm going to continue the remand if we are able to get her into sentencing even next week. I don't remember what we have next week. I have we have a trial beginning on Tuesday, don't we? Or when, yeah. So we don't have our typical Monday morning.
Oh, no.
All right. Thank you. All right. Anything else, Mr. Carnes?
No, Your Honor, thank you.
Mr. Harrison,
I don't have anything at this time, Your Honor.
have you spoken with Ms. Halliday
I
about her
haven't had the
PSI?
opportunity. I did not know she was in custody
Okay.
until this morning, and I've been here.
All right, well, the court will continue the remand until we have a motion or other decision, but we're also going to be here for sentencing in a short while. And I can tell that she had a habitual felony fourth, which gives me a little bit idea of her prior criminal history. Plus, she had a second or subsequent drug enhancement. So I know she's been on probation. So I don't know what that means necessarily, other than it gives me an idea that there could be some jail time. All right, thank you all very much. We are adjourned.
Thank you, Your Honor.
Thank you. Okay. All right, our next case is. What is it? All right, thank you. All right, next file, people of the state of Michigan versus Faylor and Thompson. File number here is Q6-14254-FH, appearances from counsel.
Lisa Dole for the people.
I'm Jeff Harrison. I'm here on behalf of Ms. Thompson. I am contending for Anna Fiervento. I should explain something, Your Honor. I believe I owe several parties an apology, including Ms. Thompson. We had initially filled out, or Mrs. Dull and Ms. Fiervento had filled out the pretrial sheet. I had turned it in and told her she was free to go because unaware of the fact that there was a bench warrant that had been issued as a result of a recent problem with a drug test or something.
Yeah.
So I did call her and she did return back of her own volition. She had left the premises and I spoke to her on the phone. I wanted everyone to know that.
No problem. All right, so Ms. Thompson, this court issued a bench warrant. You had, and that was signed yesterday. It had not been exercised, so you're here today not in custody. The court could put you in custody. We're going to figure this out in just a minute. I need to tell you that there's an allegation that's received by this court through the prosecutor's office from the community corrections office that reports that on or about May 16th, which would have been, I think, last Saturday, that you was tested positive for amphetamines and that you had no illicit prescription for such. And this was your second alleged positive test for amphetamine. And it looks like that was sent to Abbott Labs for a confirmation test as well. And it showed I'm going to say relatively significant amount because they have a cutoff level of 1,000 nanograms per milliliter. So you have the right to have due process. The court here could consider it contempt, but really what courts do, and this court's one of them, is we consider it a sua sponte review of pretrial release conditions pursuant to Michigan Code 6.106 paragraph H. And you still have the right to be heard. You have the right to have evidence presented against you. I can tell you it's not a trial and it's not proof beyond a reasonable doubt, but there could be some evidence presented to tell about whether or not you did or didn't test positive. You could be there to question and cross-examine that witness or witnesses through your counsel, Mr. Harrison, and you'd have the right to present evidence or testimony if you chose to do so, as well as the right to remain silent and not have that silence used against you. The thing here is the court could revoke your bond, remand you to custody, or modify your bond terms and conditions if you're found to be in violation of your bond. Mr. Harrison, how's your client wish to handle this? I may have gotten lost in there, but was there a pretrial agreement entered or to be entered?
No, nothing like that, Your Honor. This is, I believe, her first pretrial in this matter.
Okay.
We did complete the court's pretrial form.
Okay.
My marching orders were to have Ms. Thompson sign it and send her on her way. So that's what I did, unbeknownst to me that the warrant had been issued. So no, there's no resolution of the case. Obviously, there's a couple of things that we need to look into here. Her assertion is and has been that she has not been using illicit substances, but the positive test is there. We need to know why.
All right. Court also sees Miss Alex Smatsky from the Community Corrections Office. She's making her way here to the prosecutor's table. Miss Smatsky, tell me about the positive tests.
We have received 3 positive tests from New Direction.
Please raise your right hand. Do you swear or affirm the information testimony about the provide shall be the truth, whole truth, nothing but the truth?
Yes.
You may lower your hand. Tell me about that. When were they? Do you have any actual amounts? Go ahead.
I have 3 positive tests, one from May 13th, one from May 16th, and one from May 19th. I do not have the exact levels. I believe they can send those in for exact levels. The cutoff for New Direction is 1,000 nanograms.
Is it for amphetamines each time?
Yes.
So the 3 tests were again done on May 13th, 16th, and 19th, right?
Yes.
All right. And those are fairly close together. Were there any negative tests in between?
There was 3 tests prior to those positive tests.
Okay.
The first one was positive for THC, the second 2 were negative for everything.
Okay. Were those, hold on, when was this case found over? Prelim was on May 5th, so where was the THC, when was that one?
April 28th was the positive THC, and there were 2 more tests, May 2nd and May 4th, that were negative.
And the THC one and the 28th of April was the first test?
Yes.
Ms. Dahl, do you have any further questions for Ms. Mansky?
Yes. Did the defendant make any statements regarding any medications she was taking?
The enrollment sheet that she filled out when she signed up with us under current medication, it says no insurance.
Did she provide any proof of a medical marijuana card or discuss that at all?
No, we have no prescriptions on file.
I'm sorry, Ms. Dahl, any other questions?
No, Your Honor.
Mr. Harrison, do you have any questions for Ms. Mansky?
I do not.
All right. Mr. Harrison, do you wish to call Ms. Thompson, or do you have any other requests? I don't know. Always have it for another hearing.
I would like an opportunity to examine whatever possibility there is that this positive result is due to something other than the ingestion of controlled substances. That's been the position that she's maintained. I don't know enough about it at this juncture to.
Were these urine samples or saliva tests? They were, I'm sorry. Just tell me what, did you like, I know you can do a saliva and then do a confirmation urine. Just tell me what happened.
These are all from New Direction in Traverse City. I believe they're urine.
All right. And do you know? And lab tests were not done at New Direction, but were sent out to like Abbott Labs, is that right?
Yes, it's just a presumptive positive. We can get it confirmed.
Okay.
If we want to.
Sure. All right. Mr. Harrison, do you request to have them?
I do, Your Honor. Not to belabor the point, I would like an opportunity for a more formal hearing, just.
Well, we're going, the court's going to direct that the Community Corrections Office will have them sent out for the samples for further testing. Also, we'll have the matter set for a hearing. 2 weeks, is that enough?
That should be enough.
We'll have it set for a hearing in 2 weeks. Meanwhile, sua sponte, the court's going to modify the terms and conditions of probation that she is to enroll in and participate in an enhanced outpatient treatment program. Court does so and makes a finding that it is concerned for her health and safety as well as that of the community. Now, if this comes back and we see levels, of course, we're going to highly consider revoking bond, but we'll see. But I'm going to direct her to do this enhanced outpatient treatment program. And I'm going to highlight for you, there is no marijuana, anything. And as you told us, you don't have a card and you don't have any medications. You should test negative for everything. All right, we'll go ahead and set it for a hearing.
Thank you, Your Honor.
All right, thank you.
In this tense courtroom hearing, a woman facing serious criminal charges is suddenly confronted over multiple positive drug tests while out on bond, and the judge warns she could be taken straight into custody. The hearing begins after attorneys realize the defendant unknowingly walked into court while an active bench warrant had already been signed against her. The court could put you in custody. The judge then reveals prosecutors received reports that the woman tested positive for amphetamines multiple times while released on bond. This was your second positive test for amphetamines. Court officials explained the tests were taken only days apart and reportedly showed significant levels during laboratory screening. We received 3 positive tests. The courtroom grows tense as the judge carefully explains that bond violations do not require proof beyond a reasonable doubt, and that he now has authority to revoke her release entirely. The court could revoke your bond. Defense attorneys immediately push back, insisting the woman denies using illegal drugs and demanding more formal testing before the court jumps to conclusions. She has maintained she has not been using illicit substances. The judge then questions community corrections officers about the exact timeline of the tests, previous negative results, and whether prescriptions or medical marijuana cards were ever provided. You should test negative for everything. For several moments, it appears the woman may be jailed immediately while awaiting trial. But instead, the judge makes a surprising decision. Rather than revoking bond instantly, he orders all samples sent for additional laboratory confirmation testing and schedules another hearing in 2 weeks. We'll have them sent out for further testing. However, the warning that follows leaves the courtroom silent. The judge orders the woman into an enhanced outpatient treatment program immediately and warns that if stronger lab results come back confirming drug use, jail is likely next. The court will highly consider revoking bond. What begins as a routine pretrial hearing quickly turns into a high-stakes courtroom battle over failed drug tests, addiction concerns, laboratory evidence, and whether a defendant deserves another chance to stay free before trial. Do you think judges should immediately revoke bond after repeated positive drug tests, or wait for full confirmation results first? Like and subscribe for more real courtroom moments.